Hello and welcome to Reddy Neumann Brown's weekly updates on immigration. Every week on Tuesday at 5 o'clock Central Time, we give you the latest updates on what's going on with business immigration so you can be advised of what's coming and what to expect for your own case and know what to do and what not to do. And also we take your questions live so that you can get the answers you need for moving forward with your immigration journey. And with me today is Stephen Brown. He is a partner at Reddy Neumann Brown. Stephen, what are our topics today?
Yeah, we're going to talk about options and strategies for dealing with immigration delays in the Trump era. They've been bad during the Biden administration. I don't know how much things are going to get better. So we're going to kind of talk about planning ahead and some of the options when you're kind of stuck in that issue. We're going to talk about the 540-day EAD extension as it applies to H-4 EAD, who it works for, when it doesn't work. That's a big question that's been coming up. Unpaid leave on H-1B, what it means for status. It's been a common question, cold and flu season and all that fun stuff. And then can you still use the B2 status when you are at the end of your 60-day grace period? So we'll talk about those four topics today.
All right. So one of the major ways that we deal with immigration delays started kind of during the Trump administration. We've continued doing that is through litigation. So can you give us an idea of what types of cases litigation could work for if people are seeing unreasonable delays with processing times?
Yeah, so, we've been really focused on a handful of things, but I think it works for most non-immigrant visas, especially. H-4 EADs, H-1Bs, H-4s, Ls, all that fun stuff. Now, obviously, premium processing is available. Upgrade it to premium. It's cheaper than going to court. But we have some things where the delay can't be solved with premium. H-4 EADs is one of them. We filed 4 adjustment of status I-485 delays on Monday. Now, we talk about this in the aspect of the Trump administration. Obviously, I don't think the Trump administration is to blame for 5-year I-485 delays. But I don't think it's going to get much better. I mean, you brought it up. We saw some of these processes get slowed down during the Trump administration, the H-4 EAD, the interim benefits with the EAD and advanced parole, and, some on the green card side as well during the Trump administration. And so it's kind of continuing the strategies we see have worked and kind of planning ahead. Perfect example, Emily, the visa bulletin came out today, and we saw a little bit of movement, not much, but a little bit of movement on the final action date. I already, had somebody reach out like, we want off this ride. The visa bulletin's forward, backwards. It's gone upside down. They've been 2020 filers and want off the roller coaster. So how are they doing it? They've reached out already, and we can start planning ahead on litigating in March on their H4, on their I-485 and get there. We've had good, knock on wood, success with that endeavor so far. And we've gotten a lot of people there, over that hump.
So what does litigation look like? Who exactly are you suing? Do I have to go to court? Does my company have to be involved? Am I going to face retaliation because I'm suing someone for my immigration?
Yeah, common question. So, we bring this in district court. It's not immigration court. People, you watch the news, you hear immigration court. That is removal proceedings. That's asylum. That is not what we do. We are in federal district court, whether, all over the nation that we file in. And we sue under the Administrative Procedure Act for unreasonable delay. Sometimes we throw in an unlawful withholding claim as well, depending on the situation. And so we sue the government right now because I don't really know who the director is. I just name it Director of USCIS as the defendant. And it's individual cases because I think right now it's the best strategy. It allows us to bob and weave a little bit better, allows us to be more concise with your individual facts, for you, your family, your wife, kids. And we don't really have a policy challenge on some of these to group together. So it gets rid of some of the procedural arguments. And so We do that. Now, some of the other questions you asked, Emily, does your employer need to be involved? No. Depending on the benefit we're suing on, one, it is your benefit, not your employer. When we talk about H4 EADs, I-485s, those are your benefits. On the other side, when we talk about things that are employer-based, I think there is the zone of interest test, right, for you as the individual having the right to sue. Now, if we're talking about, for example, an H-1B, and I have an H-1B denial case that we're litigating. Her employer didn't want to be on it, and that's okay, but we're always happy to bring the employer along. But we have this zone of interest argument. And in terms of, do you have to go to court? And the answer is no. This is done. You are represented by counsel. This is, my team will handle everything. If we have to go to court, we'll be there. A lot of courts are doing Zoom still for, minor hearings. But also encourage you, like if we happen to be, near where you live and we are in court on your case and you want to go, I fully welcome it. I think it's a good experience to see people in court. It's kind of fun to watch the government bounce around in some of their arguments while the the plaintiff is sitting right there. But because this is not a criminal matter, you do not have to be there. You're represented by counsel. And then to address that last question, Emily, the retaliation, this is, I think the biggest question. I don't want to sue and just irritate the government to deny my benefits or pick on me later, anything like that. And it's pretty clear it's illegal for them to retaliate. I don't even think they're organized enough or have the desire to litigate. Our colleague that I do a lot of litigation with used to be a government attorney defending these cases, and I was on the good side. Said it was never brought up when he was a government attorney. Like, let's get after it. And, when we talk about these 485 cases, we've done, since the summer of 2022, we've probably done about 200 to 300 of these between us and our team. I've seen 3 485s denied. 2 of them were proper decisions by USCIS, a fraud finding, a status issue before filing. The third one is a long history case that we're going to take care of through court. And that's 3 out of such a big number. For the most part, these have, gone pretty nicely. Again, we can't force them to approve your benefit. We can only force them to make compel them to make a decision. But for the most part, 485s get approved.
All right. So you've mentioned that obviously if premium processing is available, use premium processing. That's one way we can overcome delays during the Trump administration. We can use litigation for things like 485 delays, EAD delays, advanced parole delays. Sometimes issues at the consulate, 221Gs go pending for a very long time. What about the PERM process and PERM delays? I know there was some litigation out there, but what is another option people have that they may be able to just avoid the PERM and skip all of that delay altogether?
Yeah, we've seen an uptick in the national interest waiver cases, the EB2 NIW and EB1A cases. Now, obviously, EB2 NIW still have the underlying issue of the visa bulletin, especially if you're Indian national. It's not going to get you your green card quicker, but there's a lot of benefits to having an EB2 NIW. One, you don't have to go through that PERM process. You can file, do it in premium, get adjudicated fairly quickly, especially compared to the 2-year-long PERM process, which is important, especially when you're maxing out. But then it's also your I-140. You're not beholden to an employer on that. EB1, A, B, C, whichever one, same thing. It's we've seen good trends on that when these cases are being done properly, and obviously little bit of tooting our own horn, but we've got a good team that's doing those cases. I think they've really figured out what's working, what's not. What do people need to do to prepare themselves? Maybe they don't qualify today, but how can you qualify in a few months, in a year, whatever it might be, to build your resume for those cases. and keeping up with the trends. But those get you out of that perm process, which, like I said, that's taken about 2 years when you start with the PWD and go, through recruitment and go through the I-9, the 9089.
You mentioned EB1. Obviously, EB1A is a tough bar to reach. EB1B for outstanding researchers. But what about EB1C? Is there a way that people can get into the EB1 category by maybe spending some time abroad for a year?
Yeah, absolutely. So, I think this is really good, especially, in the age of COVID, we started seeing this pop up more now that companies are understanding how remote work, working remotely works. And especially for people that are higher up in these managerial and executive positions. And it's not, when we talk about EB1C, it's not just I'm a manager. They are very tough on what is managerial capacity, what is executive capacity, and how you prove it. But if you kind of do the legwork ahead of time, ensure that there is a qualifying relationship between the U.S. and the foreign entity, ensure that what you're planning on doing is managerial or executive, ensure that the U.S. job is managerial or executive. We've seen people have it work. They go abroad for a year, can work as a manager, help kind of develop that team abroad with the foreign entity, still manage some of the U.S. employees too, and then come back in on their H or whatever, and apply for their EB1C, and that's working. Again, not everybody. You can't just say I'm a manager. They're not going to take that. They need to see the documents, but it can be done, and I think it's effective for those that are doing that role.
And then how about the only category that actually has green cards available immediately for people that are born in India, the EB5? Is that an option people could try?
Yeah, absolutely. So EB5, in the post Regional Center Integrity Act 2022, June 2022, it redoes everything EB5 related. And now we have unreserved EB5, a little bit of a backlog there for Indian nationals. Not terrible. I think it's 2022, if I'm not early 2022. But then there are EB5 set-asides or EB5 reserved categories for targeted employment areas, rural areas, urban areas, infrastructure projects. These are current. Now, how long are they going to be current? I don't know. You talk to some people that are in this, that do these cases and see some of these data. We've heard May possibly getting a priority date. Department of State's put that out in the January visa bulletin. It may need to happen, but it is current. Is it an easy category? No. I mean, you have to create 10 U.S. jobs, have that $800,000 investment. It's not, the easiest path to go down, but it's something that's there. And there are people that I think are looking into it, had multiple calls today on EB5. It gets you out of EB 1, 2, 3 backlog because it's current, let you lock in that age for kids, let you file your 485, get those interim benefits, the EAD and advanced parole. And they do work. And with these companies, these regional centers that have approved I-956Fs who already have shown USCIS, we are going to be able to create jobs, take on X number of investors. That can go fairly smooth. Now, not going to give you financial advice. You got to kind of analyze those on your own, but it is current. And I think people should consider taking advantage of that program while it is current.
All right, a few other things I want to mention of strategies for dealing with immigration delays. Number one is to file early. Pretty much any type of application you can file up to 180 days in advance. So if you are filing a renewal of your L1, of your EAD, of your AP, file as early as possible so that you can get the decision on it before your current document expires. That's really important for people who are filing extensions of work visas like H's and L's, because with this new administration, we're expecting new issues to be raised in RFEs. We're expecting the RFE rate to increase like it did under the prior Trump administration, even though there's been really no change in law other than the H-1B regulation that went into effect last month. But we're going to see new types of RFEs. There may be more denials than what we've seen in the past because of that, at least initially. And so if you are going to end up, unfortunately, getting a denial, if it happens before your current status expires, you have so many more options. You can refile, you can change status. You don't have to leave the country. You're not out of status immediately. So do everything you can to file early, file in premium where you can. And then the other thing is just to avoid travel, particularly if you need a visa stamp, because we expect consular processing delays to increase. We're expecting more administrative processing, 221Gs. We don't want people getting stuck waiting for a visa and end up losing the job. So speaking of waiting for processing times and losing the job, we're kind of back to where we were before with H-4 EADs. Now, we do have the 540-day auto extension, which is a result of litigation that you were involved with, created that 540-day auto extension. But what we've lost is the bundling. So we also had separate litigation that required, as per the settlement for the Ed Cooney case, required USCIS to process the H-1B, the H-4, and H-4 EAD all together in premium with one premium processing fee if you filed everything together. That settlement ended last month, which means that USCIS is going to process just the H-1B in premium. And then the H-4 and H-4 EAD, we're already seeing them split apart from the H-1B. We're seeing them go to different service centers. So those processing times are going to increase. Now, if I have my H-4 and my H-4 EAD that are expiring March 1st, I've already filed, my spouse has already filed the H-1B renewal. I've filed my H-4 renewal, my EAD renewal. H-1B is approved, but my H-4 and H-4 EAD are pending. When my current EAD expires on March 1st, does the 540-day rule allow me to keep working based on my pending EAD, just like all the other EADs that have that option?
Yeah, to quote Rahul, absolutely not. The 540-day automatic extension for the H-4 EAD is only applicable if the H-4 I-94 has been extended. So one, we're still seeing some level of bundling. More are getting separated out. They're kind of processing them decently, but people always ask, like, who does this apply to? Like, when does the H-4 actually get extended before the EAD? Well, really, I see this in two major ways. One, sometimes they adjudicate the H-4 before they do the EAD. We've seen that plenty of times where H-1B gets approved, H-4 gets approved, the I-94 gets extended, and then the EAD kind of just sits there for a few months. Now you're at least in that 540-day automatic extension. And then I will caveat, our topic last week, and Emily just mentioned it, try to avoid travel when you can. There are people, you travel, you get the extended I-94 for your H-4, you come in, timely file for your EAD renewal before it expires. Now you've got the 540-day automatic extension as well. So I get that it's not for everybody. The way the regulation is written kind of prevents the H-4 EAD from being treated like others, because you have to have the underlying status. And even though 99% of H-4s are approved, right, when you file them, they wouldn't budge on that. When they when they went through with this settlement. I get it from a technical perspective, but it is there. It's not for everybody. Again, that gets back to the file early, right? If you file the H-1B early, right now we're still seeing decent processing times on the H-4 EADs. You lessen the gaps when you file early.
Yeah, and another thing to consider if you're filing an H-1B transfer, You may not always need the H-4 to be extended along with it because you might already have your current H-1B valid for some time, but it's a good idea to, if your employer is willing, include the H-4 and the H-4 EAD with your transfer, because that allows you to have you can file it super early. If your current H-1B is still good for 2 years and you're filing a transfer, the H-4 and the H-4 EAD are still good for 2 years. Do you have to have it now? No. But because you're filing a transfer, if you include those now, you'll get that longer validity without having to face that potential of not having work authorization. And the same thing can happen if, for people who might be filing a change of status to H-4, maybe their spouse just got the I-140 approved, and so they're doing a change of status to H-4 with H-4 EAD. If you file that by itself, it can take 8 months to process. So if there's a way for you to file it along with the H-1B, maybe file an amendment to file the H-1B early, you may be able to have slightly faster processing time, but they are stopped bundling, which makes it more difficult. But at least if you can file it earlier than 180 days, that buys you some extra time. Next topic we want to discuss. We've been getting a lot of consultations lately, a lot of people on our daily conference call asking about taking an unpaid leave while you're on H-1B. And I want to start off by saying there are various types of unpaid leaves. Some of them are legal, some of them are not. So we're going to kind of talk about which ones can be okay for H-1B and which ones are definitely not okay for H-1B and can put you out of status. So number one, maternity leave. Let's say if you are pregnant, going to have a baby, and your company provides for maternity leave, but it's an unpaid leave, and you want to take a couple of months off, and that's in line with your company's policy, you can absolutely do that and still be maintaining your H-1B status, even if you're not getting paid, even if you're not working. Same thing with a medical leave. If it falls under FMLA, the Family Medical Leave Act, where your company has to give you up to a certain number of weeks of time off to deal with a medical emergency, even if it's unpaid, that still counts as being employed, being in H-1B status, maintaining your status. So those are both fine. But what about the other issues? Maybe you're just facing burnout and say, you know what, I just need to take a break. I want to take off for the next 6 months and I'll come back to work later. Is that something that is allowed? Is that going to mess up with your H-1B status?
It kind of gets back to what is the company's policy and how is this being, done. If the company's telling you, hey, take an unpaid leave because we don't have a project for you, no, that's unlawful benching and that's illegal. But yeah, truly, I think if the company's willing to say you need a sabbatical and they've got a policy that offers, you can take a sabbatical. There are companies, they understand mental health. You need to take those breaks. As long as it's aligned with the company policy that's offered, then that's fine. I mean, I think document it, make sure it's all there to document. The big question we always get, Emily, is how long can this unpaid leave be? Can it be a week? Can it be 3 months? Can it be 6 months? There's nothing out there.
Yeah, I think it's got to be reasonable. It's got to definitely be in line with the company's policy, and it needs to be reasonable. As I mentioned, maternity leave. Can you take a 3-year maternity leave? Probably not, and still be maintaining H-1B status, but maybe 6 months. I don't know. I think it just depends on what's reasonable to your company and what they're willing to do. I think the biggest thing is, does the company have a policy? What does that policy say? And are they offering you under the terms of that policy? Then I do think that it's generally okay.
Yeah. And, I think you got to look at that. Some companies, it's kind of broad about unpaid leave being in the discretion of managers. I mean, that's fine. It really just, again, does. And we keep mentioning paternity leave is okay too for those of us that, are going to need that. But yeah, just be cautious because I think there are some bad actors out there, Emily, that'll tell you, hey, Emily, we want you to take an unpaid leave. Your project ended. taking unpaid leave. And I think that's a violation of the LCA terms and conditions. It's a violation of the regulations. That's a violation of your status. So just kind of see what's going on with the situation.
Yeah, absolutely. If you are being benched because work is not available, the company has to pay you. You cannot be told to take an unpaid leave, even if you agree to it, even if they say, hey, will you write this letter requesting to take an unpaid leave for your own personal reasons? That's still not allowed. And that can be, as you said, violation of your H-1B status, also violation of the LCA rules. It can cause trouble when you are filing an extension of your H-1B. It can cause trouble when you're going for visa stamping. So definitely avoid those kind of situations. And then the last topic I wanted to touch on before we get to questions is, this idea of we're at the end of our 60-day grace period after a job loss. Is it still possible to change status to B2 to kind of buy an extra 6 months? Because that was something that the Biden administration just kind of started allowing us to do. It was just posted on a website. We saw it in a random tweet from USCIS. I don't know. Do you still call them tweets on X? I don't even know.
I still do. I haven't figured out what is it, like tweets or whatever. I'm calling them tweets on Twitter. I'm not there yet.
Yeah. So are we still able to file a change of status to B2 if someone is nearing the end of their 60-day grace period?
Yeah, it still works. I think this was March 2023. They come up with this policy. Don't announce it. It's just kind of there on an FAQ, and they put it up there. In the past, the issue was twofold. One, can you use that B visa to job search? And they put the guidance out there saying, yeah, we think it is. Now, I want to be very clear. I do not think Department of State is going to issue a B visa at the consulate. I do not think CBP is going to admit someone on B status, to job search, but USCIS accepts it. So you have to understand the difference there. USCIS thinks it's fine. Don't go apply for a B visa saying, I'm trying to job search. They'll deny your visa. But it works with USCIS. And then the other issue we saw is that while it's pending, these take forever. How do you get back onto H-1B? Well, you'd have to consular process, and then you'd have to go travel. And part of this policy says that, hey, if you're on that B visa pending and you're going to change your status back to H-1, and you do that in premium, we'll approve the B visa. So that way you're in status instead of just a period of authorized stay. You're in status. You're going to be on B1 status. And then the next minute they'll approve the H-1B. I know that sounds like it's an unnecessary technicality, and it probably is nothing more than a technicality, but it's how it has to work functionally. It works now. I will say a couple things. Do we see RFEs on this issue? Yeah, absolutely. This is a policy that I don't think every adjudicator knows. I have had RFEs where I've had to explain, no, here's the policy. That's okay. I haven't seen one of these not work yet. And then the big thing, Emily, is, you file that change of status from pending B to H-1B. When can I start working?
Yeah, so for that, because once you've gone out of the 60-day grace period, you're no longer in H-1B status. But because your change of status to B2 is still pending, you're not yet in B2 status. So you're not really in either status. And the only status that allows you to work while a transfer is pending if you're already in H-1B status at the time of filing the H-1B. So because you're no longer in H-1B status, you're not authorized to work until your new H-1B gets approved. For that reason, we generally recommend employers to file that in premium processing so that you can start in 3 weeks rather than waiting 4 to 8 months under regular processing.
And real quick, we'll start getting to questions here. We've had a number that I've been watching here pop up on the birthright citizenship issue. So let's, I know big topic, right? As far as I know, that is enjoined by multiple district courts. I know it is up on appeal in the 9th Circuit. And I saw somewhere another circuit that they filed a notice of appeal. This is eventually going to become a Supreme Court problem, right, down the road. But right now, the Trump administration is enjoined from enforcing the executive order that doesn't recognize somewhat birthright citizenship. So to those asking, I don't know how this is going to play out in the long run. I don't see a situation where if you have a baby today and that the Supreme Court decides this later this year, early next, that they're going to say it's not a citizen. I think it would take effect upon the ruling. Obviously, I could be wrong. And then somebody asked a question if they, the federal government would not follow and just not issue passports. I did some digging in this when it started popping up. I think there's a requirement that if you are a U.S. citizen, you are entitled to a passport. I don't think they're going to just stop issuing passports. So I know birthright citizenship, hot topic. I don't think we're going to see a lot of movement on that probably for the next couple months, unless some of these circuits move very, very fast and it gets up to the Supreme Court much faster than most, which it might. It's a, interlocutory appeal on an injunction. It can get fast tracked, but I still think we're talking about later this year.
All right, we can go to some questions now. Rajan wants to know if there are any issues with traveling on AP, advanced parole, under the Trump administration. So generally, no. We found during the prior Trump administration, advanced parole based on a pending I-485 application in the employment-based category was safe to do because you don't require stamping. Even when there were multiple visa bans and travel bans in place, people were still able to travel on AP. So we would expect that to continue. Just one thing to be aware of, because the Trump administration has recently announced the end of several parole programs that were more humanitarian based, sometimes officers at the port of entry, when they see your advanced parole, because it's called parole, they think, wait, I thought Trump canceled all the paroles. And so we've had some people report that they had to stay in secondary inspection longer than normal while they got a supervisor and figured it out and realized, no, this is a 485 AP. This is not a humanitarian parole document. And the person was allowed to come in. So you may just want to carry your 485 receipt notice with you. But beyond that, it should be generally safe.
Question here from YouTube. If USCIS says to use the final action date chart to file adjustment of status, then what is the point of having a different higher value, in the date of filing chart for EB2, EB3? So, they do this, they use the final action date chart with USCIS's side because, they're going to still take on some petitions. Maybe your PERM just got approved. You changed companies and your PERM just got approved. So now you can file the I-140 and adjustment of status. But you have to understand these charts serve two different functions. The date of filing is when you can kind of start the adjustment of status or consular processing for a green card. And the final action date is when when a green card becomes immediately available to you. And in the eyes of the USCIS, the Immigration Nationality Act, you are entitled, you can receive a green card. If they got rid of the date of filing and you only had one chart, then they would only keep it with these final action dates. Nobody would be able to file their 485 unless it was before that. This kind of gives them that period of letting them work on it. You get those interim benefits, the EAD and advanced parole. So I get it. It's frustrating. It doesn't make any sense sometimes. But it is somewhat good to see the final action date keep moving because as they keep clearing out the 2020 backlog slowly but surely. Eventually, we'll get to new filing dates. Eventually.
Yogita says, I'm planning to travel to India for visa stamping. I have a Dropbox appointment. Will there be any issue? And there could be. There's possibility everything might go through just fine with the Dropbox. There's a possibility that you might get called in for an interview, even though you have a Dropbox appointment. And there's a possibility that Trump implements a visa ban right while you're sitting outside the country and haven't gotten your visa yet. If there's a visa ban, you're going to be stuck. If you get a 221G, you're going to be stuck. Now probably is not the time to travel if you need to go for visa stamping, unless you must travel because you need to figure out something with your status, or you're converting from one status to another. So there are very few reasons why someone must travel to go for visa stamping. So unless it's one of those few reasons, you may want to reconsider this
Question
trip.
from YouTube: how long do we have to wait before it makes sense to sue on a pending I-485, assuming both dates are current? This is a very moving question. Some cases, I'm more aggressive with maybe an EB-5 set aside and an EB-1 because of the way Congress kind of framed those, and I brought some of those at about a year. EB-2, EB-3, I'd like to see at a year and a half, but if we get across that year threshold, maybe there's some urgent matters or something that makes it different. You can't, a lot of government jobs aren't available unless you have a green card. And so there's a lot of reasons. And, like Emily was just saying, travel, when we saw the travel bans, green card, holders were exempted. Not always were non-immigrant visa holders exempted. So I think there's a lot of reasons to kind of push for this when you can.
Atanu says, my 485 in the EB1C category has been pending for more than 10 months. My L1A extension is approaching. Can I dump this visa status and just be on the EAD and AP? Assuming that your I-140 in the EB1C category is approved, probably. We have many people that avoid the non-immigrant status once they have that EAD and AP, and once their I-140 is approved. Assuming your 485 is a clean case, there's no like criminal issues or prior immigration violations or things like that that could potentially cause a 485 to be denied. The biggest issue is AP. Hopefully you've gotten an AP that's valid for 5 years, so you don't have to worry about it. But for people who are thinking of letting the non-immigrant status go, if you need to renew your AP and it expires while your renewal is pending, you can't travel because you don't have that non-immigrant status anymore. So that's one area to be careful of if you do decide to drop the non-immigrant status and just rely on the 485 with the EAD and AP.
Question here, can we work while an EAD has been denied but are filing a motion for it? No, I think until they actually reopen the I-765 and that would work for the grace period, or they reopen it and approve it. I don't think you can work just by filing an I-290B. I am filing one of those this week for someone, and that's been my advice for them as well.
Kala Gotla says, my H-1B extension is due June 30th, 2025. I have an implementation partner, a preferred vendor between my employer and the end client. With premium processing, when is the best time to file? January 30th, 2025. You should have filed 2 weeks ago. So if you haven't filed yet, file immediately, because as we mentioned at the beginning, if you're filing in premium processing and you get a denial before June 30th, you'll have many more options to figure out what to do with your status, and you can stay in the country while you do that. If you wait until June to file and then you get a denial after June 30th, there are very few options. You most likely have to leave the country unless you filed something else before June 30th.
Question, YouTube here. Are there an unusually high number of portings from EB2, EB3 to EB1C contributing to the backlog? No, I don't think it's necessarily EB1C, but I think there are people, the Biden administration put out some policy guidance related to EB1A and O1 and NIW related to emerging technologies and AI. And a lot of people that may not have qualified for an EB1A now realize that might be an opportunity for them, even if they didn't consider it, and, took that memo to heart and started pushing for it. So I don't think it's EB1C necessarily, because I think we see more EB1A and B in those fields than we do EB1C.
Tech Topics from YouTube says, I lost my job in October, filed for compelling circumstances EAD, and also filed for a change of status to F1 before the end of the 60-day grace period. both the F1 is approved and the compelling circumstances EAD is approved, currently pursuing the master's on an F1, but have a business idea. Can I suspend or terminate my F1 status, switch to the EAD card, and commence the startup and also continue the master's? Can you? Yes. Should you? Maybe, maybe not. So yes, that EAD allows you to work on your own business. It is an unrestricted EAD. But if you forego the F1 status and work pursuant to this EAD, there's no way for you to get back to a non-immigrant status without exiting the country, because that compelling circumstances EAD is just work authorization. It is not status. It allows you to be lawfully here, but you're not considered to be in any non-immigrant status, like an H, an L, an F, a TN. All of those are non-immigrant statuses. And the only way to change status from one status to another without leaving the country is if you're in a non-immigrant status at the time of filing. So let's say you use this EAD for a year from now, you decide you want to convert to H-1B through the self-sponsorship option, because now you can be a business owner and pursue H-1B for yourself under certain circumstances. You would not be able to do that from within the US. You would have to file a consular processing H-1B. Once it gets approved, exit, apply for a new H-1B visa stamp, assuming yours has expired by then, and then come back in. So it just adds an extra layer of hassle and risk. Other than that, yes, absolutely.
Shree on YouTube asks, is I-45 EB-1A move from National Benefit Center to a non-local field office remain pending, even though it was current under the final action date? Then now Emma says it moved back to the NBC. Yeah, I see this fact pattern quite a bit, especially if you ported an old priority date over. I don't know what is going on with their systems. You're not the first case where I've heard it like change that case remains pending and it's saying it's not current, even though you should be. We have used litigation on it as a good tool on that, both from a delay case and an unlawful withholding, because I don't think they're properly notating it. It's worked out pretty well. But you're not alone in that, Shree. I'm sorry to say. Feel free to reach out. Happy to have a talk on that, because it's happening. And I think sometimes, litigation can shake some trees loose too.
Naveen Kumar from Facebook says, my AP is approved for 5 years, but when I return to the US, the officer stamped it for just 1 year, and my I-94 is also only for just 1 year. Does this mean we can continue to stay in the US until the AP expires or the I-94 expires? And the answer is neither of the above. Once you come back on AP, that I-94 online, that end date is irrelevant. You can stay in the US as long as your 485 remains pending. So it's not the AP expiration date, it's not the I-94 expiration date. Once you come in on AP, as long as you are continuing that 485 process, you can remain in the US even though that I-94 expires. Now, if you're coming back into the US and intending to continue your non-immigrant H or L status, then the I-94 that's on your H-1B approval or L-1 approval is the one that you do need to pay attention to and make sure you file a renewal before that.
Question here from Shiva on YouTube. I heard Canadian citizens don't need visa stamping. So is an H-1B visa not needed for us then? Only the I-797 suffices. Yeah, so Canadian citizens are visa exempt, meaning you can apply right at the port of entry. We can but we can prepare TNs, L1s right at the ports of entry. For an H-1B, you have to get that approval through USCIS. Take that I-797, show it to them. You don't have to go for visa stamping. Nice little tool there to use.
Sam says, is there any problem for the company or the employee in H-1B status if they work for more than 3 months when they're outside the country, outside the US? No. So assuming that whatever country you are visiting or working at, you have work authorization for. So assuming you're at your home country, no issues at all. When you're in your home country, U.S. immigration law does not apply to you. You don't need U.S. work authorization in order to work from your home country. And remote work is an option, but it's based on where you're actually sitting when you're doing that work. So if you're sitting in your home country, you do not need U.S. work authorization. You can work remotely. There may be some tax consequences to that, but beyond that, there's no immigration law compliance required for that.
Good question here from Alec on YouTube. Relocated from one state to another, same job 10 months back, but didn't file a supplement J. Now my priority date is going to be current starting March 1st. Should I wait for the RFE or file a supplement J now? What do you think in that situation, Emily? I know we always go back and forth, preemptively filing supplement Js, not preemptively. Do they actually care? Are they going to send the RFE anyway? Does a change in the state require a supplement J?
I think I would just generally wait until there's an RFE nowadays. I don't see any negative consequence to not proactively filing it, if that makes sense.
Yeah, I would agree. That's typically, this comes up a lot when I talk to my litigation clients, especially the EB2, EB3 folks that downgrade, upgrade, all that. Do they need a new supplement J? And, I think until the government asks you, they don't need to do a supplement J, right? They can approve it without one. So if they don't ask for it, there's not a binding requirement it's not like an AR11, right? Where because you moved, you have to file one.
Kishore says, do you see any issues with H-1B extensions with the Trump administration executive orders? Nothing yet. I don't think there's been any executive orders that change how H-1B extensions are being processed. The good news is that the H-1B regulation that took effect on January 17th actually made deference to prior approvals, put it into the regulation. So it's not something that can be easily undone. Like the previous administration, when we were having difficulties, RFEs, denials with extensions, it was because Trump eliminated the prior memo that said you have to defer to prior approvals unless there was a gross error. So because that was just a memo and not in a regulation, Trump could easily get rid of that memo. And then Biden brought it back. But now Trump can't get rid of it because now it's in the regulation. So that's one good thing. But we do expect to see new types of RFEs for H-1Bs in general, partly because it's a new administration. So every time there's a regime change at USCIS, we do see new templates, new issues raised in RFEs, even on extensions. But also because of this regulation that took effect, they've kind of modified how they look at specialty occupation. They've modified how they look at third-party placement. So we're expecting to see some new issues for that reason as well. But I've not seen any yet.
Two somewhat related questions. Do you think there's a possibility of getting an EAD for people with an approved I-140 and Eagle Act? Do we think it's going to pass? I wish some of these things would happen. I think Emily and I both would tell you we wish they would. I do not see much happening in the way of positive immigration reform in the 119th Congress. My personal opinion. That's not to say it is not worth writing your congressman. I think you should. I think you should write your congressperson, your senator, and push for it. I do not think the political climate is there personally, but stranger things have happened. Remember, 2022, we got a whole bunch of EB5 stuff done in an appropriations bill. I think it's worth still trying. I just don't see a lot of people wanting to be pro-immigration right
now. RK007 says, are there an unusually high number of portings from EB2 or EB3 into the EB1C contributing to the backlog? I don't think it's a high number. I think it's a growing number. There's not any tracking of the number of people doing this as far as I'm aware. All of the data we get just tells us which EB1 category people are getting approved under, and the percentage that are EB1A, EB1B versus EB1C. EB1C is the highest percentage, but it's been that way. So that's not new. I think what's new is the porting with people retaining that priority date that are jumping in line ahead of the people that were originally in EB1, regardless of whether it was A, B, or C. We have no tracking of that. So it's just based on what we know we're doing in our firm, what we know our companies are doing. So yeah, it's happening. Yeah, it's increasing, but I don't think it's a substantial
Interesting
number.
question here from Diraj.
Yes.
My priority date, December 2021. I'm Canadian permanent resident. Should I wait for Canadian citizenship or to try to come on an L1A and request employer to do an EB1C? So common misconception. Getting that Canadian citizenship can help you with a TN, but from the green card standpoint, it doesn't matter. It is where you were born, and that is it. So unless you were born in Canada, that gives you no benefit on the visa bulletin. Now, if you can do that L1A and EB1C and you qualify for all that, I think your priority date's current under the visa bulletin, if I remember right, December 2021. That's obviously a different fact pattern, but being getting your Canadian citizenship is not going to change anything related to the visa bulletin.
Ram says, my spouse is an H4 dependent, traveled to India 3 weeks ago. She has a valid advance parole document, but her green card was approved last week while she's in India. How can we proceed to enter the US? So that's a good problem to have. Congrats that the green card was approved while she was out of the US. And it's generally not a problem. So she will probably need to use her advance parole to get on the airplane. Because obviously she won't have the green card with her, but she can use that to get on the plane. Once she lands, she can go through the green card line. The people at CBP will be able to look up her case and confirm that she is a green card holder and let her in as a lawful permanent resident. I've had this happen many times. Usually if you know what airport she's going to land in the U.S., your attorney can call that CBP office and just verify, see if they want any particular documents for her to carry. But I've never had anybody have trouble.
Yeah, I mean, we had a big discussion on this not too long ago. I've also talked to outside attorneys too. Never seen any problem. It happens. I saw this question pop up. What can you do if your employer is not willing to sign the supplement J? Keep asking. I don't think you can submit a supplement J for an EB2, a perm based EB2 and EB3 without an employer.
Yeah, time to find a new employer, file an NIW if you can, become a free agent. Yeah, unfortunately, there's no way to proceed without that.
Yeah, frustrating for sure.
Okay. Yeah. Rajesh says, I'm on STEM OPT. My H-1B is already approved with consular processing for my current employer, but can I work with a new employer on the STEM OPT? And then can I transfer my consular H-1B to the new employer? So yes, you can work with the new employer on STEM OPT, but no, you cannot transfer that H-1B to a new employer because you have not actually been counted in the cap yet. You got the approval, you got selected in the lottery, you got the approval, but because you have not been admitted in H-1B status or granted the visa, those are the things that actually make you counted. If a new employer were to try to file a transfer, they would say you've not been counted in the cap and just deny it. So you either need to get your current employer to file a change of status to H-1B, and then once that's in place, then you can transfer to a new employer in H-1B status, or you need to go for stamping, and then a new employer could. But of course, to go for stamping, you need to have the job and be intending to work with the current employer.
Question from Gorgeous Wilderness here with a nice profile picture. Do I need to file I-485J for EB2 to EB3 downgrade as EB3 is going to be current in March? This is what I've done with my litigation clients. I assume you're probably around that 2020, 2021 filing, is to send it in, and then we can say you're eligible and sue on it right away once it's mailed in. That way we've gone about it. I've also had cases where they have sent emails saying, hey, we need them to write a letter confirming that they want an EB3 instead of an EB2. And I'm like, okay, we can do that exercise. But you can file that 485J to downgrade it and then file a litigation right away.
As my PERM was denied and my H-1B 6-year limit is ending May 2025, can I apply for the 7th year extension with the PERM reconsideration request? Yes, a reconsideration request is considered to be as if the PERM has been pending the entire time. So as long as it's been pending for at least 365 days by the time you would hit your 6-year limit, you can use that pending reconsideration request to get an additional year of H-1B time.
Question here: any policy changes foreseen on on naturalization going from the green card? Any new forms or regulation changes expected? Naturalization didn't get impacted all that much, other than delays during the Trump one and that cave that all the naturalization cases were in that nobody could get to during COVID. Maybe they're a little stricter on good moral character and stuff like that, but I think it's good to go.
Sucker says, I have my H-1B approved till 2027, but my I-94 has an expiration date of July 2024. Do I need to do anything to get it updated for I-9 re-verification? So kind of depends on the situation here. I'm hoping that when you say your I-94 expired in July 2024, that's the one you got online before you filed your H-1B extension. And then you got your H-1B extension approved till 2027. That has your new I-94 on it. So if you filed the H-1B after you traveled, that H-1B has your new I-94. You don't look at the one that's online. The online I-94 won't change because of the extension approval. So you use the I-94 that's on your I-797 for re-verification on your I-9. Now, it's a different story if you got your H-1B approved till 2027 and then you traveled, and for some reason when you came back in, they gave you the end date of July 2024, then you need to speak with an immigration attorney as soon as possible to figure out what your options are. I'm hoping it is the earlier option and not the later option.
Feel free to reach out on litigation. You can email us info@rnlawgroup.com. Employer has less than 5 employees and no direct clients. PERM was filed in June 2024. What are the chances of RFE or denial? I don't think the no direct clients is going to negatively impact the PERM. I don't think that less than 5 employees, maybe they want to audit a little bit different, but I don't think just the size of the company is an audit trigger.
Vitaly says EB3 rest of world moved just 2 weeks in 18 months. Is there really such a large backlog? This category went from current to backlog in the last couple of years. Yeah, there definitely is, for a couple of reasons. One is COVID. And EB3 tends to be used more by people who are outside the US being sponsored, like in Schedule A for nurses and physical therapists, for example. And so during COVID, there was an immigrant visa ban. And so those people who were in the EB3 category could not get their immigrant visa at the consulate and could not come into the US. So that created this backlog of people who were waiting for the consulates to reopen. So that kind of part of it is what started it, but also there's just been more demand from the rest of the world. More and more people from all over the world are coming to the U.S. on work visas. More and more are being sponsored for the green card. So that also has built up this extra demand. I mean, there's only, if I'm doing my math right, 28% of 140,000. You would think I would know this on top of my head. 39,000 green cards available in the EB3 category for the entire world. So yeah, there are that many people that are waiting.
Question here from Rahul on YouTube. I am filing my EB1A with my priority date current. Should I file I-485 with it or not? I think it's a very strategic question. I mean, if it's a good EB1 case, I think you can concurrently file. I mean, your worst case scenario is you've applied for a 485 and it gets denied because the I-140 gets denied. But I think there's some benefits to filing.
Nitin says, my prevailing wage for my PERM application came out higher than my current salary, but my PERM recently got certified. When do I need to make sure that my salary is the same as the prevailing wage? So there's two aspects to that. One is when your company goes to file your I-140 petition, they need to show that they have the ability to pay that higher salary. Now, that's easy to do if you've already been paid that higher salary, but since you haven't from the time of your priority date, the company needs to be able to show that they have the income, the net income or net assets to make up the difference. So that's one aspect where it comes up. Otherwise, they need to pay you that wage when you take that job, when you actually get your green card. I think we are out of time for today. That sure went fast. Thank you everyone for joining us. We will be back again next Tuesday at 5 o'clock Central Time. And be sure to subscribe to our newsletter, subscribe to all of our different channels. And I did want to share that Stephen and I have recently launched our very own podcast called Visa Vibes. You can find us on YouTube, but also on Apple Podcast and Spotify. So check it out. We've got our second episode posted today, and we are getting ready to record our next episode tomorrow. So we hope you like it.